Oh, okay. All right. Very good. Yeah, because I noticed in the hearing procedures that apply to this, it said it had to be a public hearing. So I was curious. I mean, if members of the public wanted to patch in, can they do that through Zoom, or is it just participation by watching the YouTube link?
Mr. Olbrecht, they have the ability to live stream through the YouTube link as well as attend via Zoom. You can log in through zoom.us, enter the meeting ID. You also have the ability to call in the telephone number to enter Zoom.
Okay, all right, that's good to hear. I mean, the fact of the matter is, though, this appeal is limited to the city and the appellant, but since it is also required to be a public hearing, the public has a right to at least watch what's going on. I don't anticipate that the public would have any need to object to anything or interject anything. As I said, they don't have a right to participate, but if any members of the public out there, for whatever reason, do feel that there's something they need to say and they need to be heard on it, then use the Zoom link that was advertised for the hearing there. The hearing format today will be, since as a general proposition, usually in these kind of appeals, the city has the burden of proof. They would present first and last, with the appellant, in the middle, having the chance to rebut what the city presents. If the parties want to do the format differently, that's up to them by mutual agreement. I have no problem with if the appellant and the city agree that the appellant should go first. Also, I got a request yesterday for confirmation that we're having a hearing today. Was there some confusion about whether their hearing was to be held today, or I see both the attorneys for both sides are muted. I just want to make sure that we're all clear we're holding a hearing this morning. Mr. Harper?
I think maybe just confirmation that it was going. I'm not aware of any issues.
Okay, very good. Yeah, I did email the parties in advance to ask how they wanted to deal with what essentially, I construe as a city motion to dismiss due to lack of jurisdiction. I inquired whether the parties wanted to make this a two-step process where we just deal with the jurisdictional issue today and defer the substantive portion of the hearing for later if the motion isn't granted. And the city didn't want to go that route because of the need to resolve this in a timely manner, which is fine. I needed agreement from both parties to do that, but don't have that, so that's okay. I do think it's a good idea to deal with the jurisdictional issues first. I'll probably take them under advisement, and we'll, after that, we'll move on to the hearing in chief. But I'd certainly like to hear the arguments on both sides on the jurisdictional issues. And since that's the city's motion, I'll allow you, Ms. McCain, to go first on behalf of the city if you want to add anything to what your brief had in this particular case.
I'll try to be brief because the brief wasn't as brief as it might have been otherwise, 10 pages. But essentially, it comes down to this, Mr. Olbrecht. We've had this rental housing program for 6 years. This rental housing property has been renting for that entire period of time, and we have no license on record. They have never applied for a license. So that's the first point. The second is that we have evidence that they haven't followed many of the rules, not just the licensing, but also obtaining permits for work that's been done since, I think, even 2018. Mr. Gum can speak to that. Finally, looking at the terms and the process in which the hearing examiner is given jurisdiction by the city council to hear these types of matters, the city council has limited the scope of these kind of hearings to those people who are either licensees or applicants. And as I said, this property owner has never had a license, so can never be considered a licensee. Secondly, the only time this property owner has been considered an applicant was when, rather late in the game, March 30th, the property owner filed an application for a license and was actually conditioned as we would condition anyone under this program. So regardless of whether the hearing examiner decides that the jurisdictional issues should end this case or not, the fourth point here is that substantively they have not complied with the code, and the code is based on state law. They have not explained in any way, shape, or form in their appeal why they are exempt from this code provision and why they've been unfairly targeted or treated under the city's code. So we would ask that the hearing examiner sustain our ruling. So, and again, because this is an unsafe building, unsafe rental unit, and frankly, we may have to refer this to Adult Protective Services because the property owner may have created a problem with one of the rental unit tenants. He apparently knows the property owners or the families are somehow connected. There's some evidence that he has some cognitive difficulties. And even though the city has posted the rental unit as unsafe and uninhabitable, he wants to remain, and he has refused the city's relocation assistance. So it's not clear to me if there's been some manipulation or some other action that is putting this rental tenant in jeopardy. So I'm also a little concerned about that, which is why we don't want, as the city, any further delay. The only way we got this property owner into a conversation with the city apparently is the threat of the imposition of the rental housing relocation, which we then give the tenants and collect back or get reimbursement from the property owner. That seems to be the only reason this property owner is coming forward. So that is the city's position. And again, I would have appreciated Mr. Harper providing something in writing beyond the appeal, but I feel like I'm in a position of just guessing what his position is here. He hasn't provided much, if anything. So
okay, and so on the jurisdictional issue, looking at 56120C, addressing the city's argument that this only applies to licensees and those related. The language is a little contradictory on that. It says all license application denials, suspensions, or revocations shall be in writing. Appeals of actions taken under this chapter, which of course is, you can construe either as just referring back to the license applications, denials, or suspensions, or you could construe that as applying to any action taken under the chapter, which is, I'm sure, what the appellants are taking, are governed by a 5.02. The language that bothers me a lot in that second sentence says, except as provided by LMC 56130 or 56150. So and those actions aren't actions of license, denial, approval, or revocation. Those are, warrants for searching property. And let's see, I don't recall specifically. Well, oh yeah, 150 was, seeking misdemeanor charges, that kind of thing. So, I mean, I would think the appellant could say that the reference to actions in 560 120C references any action taken under the chapter can be appealed as governed by 5.02. And I know 502 says, that licensees and applicants have the right of appeal. But again, those people don't necessarily need to be licensees or applicants under 56130 or 150, which is cross-referenced as relating to actions. I mean, do you see what I'm saying there?
Yeah, I do see what you're saying, and I believe you're making Mr. Harper's argument for him. But if I could respond,
I want to get your side.
Yeah, no, I understand. But I believe that 560, the rental housing inspection program, and that you're right. It does say appeals taken, appeals of actions taken under this chapter is qualified first by that first section, which says denials, suspensions, and revocations. It's also qualified by its reference to chapter 5.02, which again, as you pointed out, says that the hearing examiner is designated, and this is your jurisdiction. You are limited as the hearing examiner to only those appeals by applicants or licensees aggrieved by actions of the city. And again, it refers to denial, revocation, or imposition of any conditions. So this property owner has never been a licensee, never, not as far as we're concerned, and has only been an applicant as of March 30th. The only imposition that we put in terms of the application that is pending that the property owner filed for on March 30th is the same kind of conditions we impose on any rental housing, which is you got to pass an inspection and you can't rent until you pass that inspection. So that's all consistent with state law and the city code and should be sustained. So that is the city's position.
Okay. And so, and to be clear then, so that was going to be my second question. So they haven't gotten a decision on their license application yet, but it has been conditioned that they take this inspection. Is that inspection have to be done before they get a decision? Is that how the process is going to work?
Yes. I mean,
Okay.
they cannot rent at all until they have a certificate of inspection here. And they have not passed. And in fact, they hired a private inspector, which is an option under the code. You don't have to have this done by the city. And that has been found unsafe. There were a number of problems with these two rental units, which is why, again, with confirmation by that private inspection, we actually issued the relocation assistance, or at least attempted to. And these are two units. One accepted it. The other, again, it appears to have some cognitive difficulties and or maybe being manipulated by this property owner. I don't know, but I know that the city is a little concerned here. We have an unsafe building where someone will not leave, and this property owner is not taking care of it. And I'll correct myself. I think Mr. Gunn will explain that they have attempted a couple of times, but without any permitted work. So that's another problem.
Okay. Now, if I did find that just any action taken under the chapter is subject to appeal, the city's argument is that the appeals are untimely. I mean, I can't remember. Is the March 20? What's the date of the appeal again? Is it April 6th or?
No, let me see when they actually.
No, it was March 30th, I think, right?
I think it was March 30th.
Okay.
And again, I'm not really sure what they're appealing. Their appeal talks about a decision to identify the property as unlawful to rent. That was a decision that was made long ago, and they have missed the deadline on that for sure. Right. They also asked for an appeal on the decision to relocate tenants. And of course, we're not relocating tenants. We're offering relocation assistance. And again, they've missed the deadline on that as well. And then the imposition of fines. And I don't know where they're talking about imposition of fines. They came in and applied for a license. Since they didn't have a license, they were given double fees. If that's what they're talking about, again, they should lose on that because that is consistent with the city's code. It's right there. It's not a question of any kind of overreach by the department at all. So they should lose on that, and that should be sustained. And for the record here, Your Honor, I get that judges, courts do not want to see these kind of cases come before them. They generally want these handled at the administrative level. So that's another reason not to bifurcate this hearing as in jurisdictional and then on the merits, because I've been to Superior Court for 30 years, too many times where a judge says, we like to have it fleshed out by the administrative official first, and then we want to take it. Because frankly, they don't want these cases. So if that's the way you want to handle it, take it under advisement, and then we can move on to the hearing on the merits. I understand that as well.
So are you on your last point? Are you saying that even if I find that there is no jurisdiction, you actually would prefer findings and conclusions on the merits of the case in case the trial court?
Actually, I would. Yeah.
Oh, okay. Well, that's helpful. Actually, yeah, I was going to be asking that today as well. Well, okay. So so obviously this is a timely appeal of the March 30th or 23rd notice, I mean to say, because it was within 10 days, if that kind of action is subject to appeal. So to kind of flesh out that particular issue, again, if I were to find that any action under the rental housing chapter is subject to appeal, I mean, then we have to flesh out what's too late to challenge and what can be challenged under the March 30th appeal, or March 31st, I should say. And the way I look at it, and see if you agree, is or one potential way of looking at it, I'll put it that way, is that the earlier notices basically said, if you don't correct the problems that the city sees here, we're going to require relocation of the tenants. And at this point, we're declaring that this property is unlawful to rent. And so what all the March 23rd notice provided, and also that there was one on March 30th as well, was the amount of that relocation assistance. So is the amount basically all that's left to challenge if the earlier notices are?
I don't think that they even have a right to challenge that as well. They can try, but again, it's consistent with the statute, not only the statute, the state statute, but the city code as well. And I don't think that they're timely. The unsafe conditions were determined much earlier than that. March 2nd, both on February 11th and March 2nd, they were given notice. And then on March 5th, it was posted on the property as non-compliant. They never appealed any of those notices.
Right.
Never.
But they were never told what the amount was, right? So
right.
It's like that. You can say there's a right of relocation, and it's just an issue of, did the city correctly compute the 3 months that has to be paid, or whatever is required by code.
And I don't see anything that gives the hearing examiner the authority to review the relocation amount. I think you're reading that section of appeals of any actions taken under this chapter too broadly, because again, that is qualified by the previous sentence that says denials, suspensions, or revocations. And it's also qualified by the reference to 502, which again applies to, or you hear appeals from licensees and applicants, and only of those type of actions.
Okay.
Denials, suspensions, revocations.
All right, perfect. Thank you, Ms. McCain. Appreciate your argument on that issue. Let's move on to Mr. Harper then to address the jurisdictional issue.
Thank you. Essentially, I think you did make my argument, and I think that 502-190 does show that there is jurisdiction here. It seems strange to me that the city would take the position there's no right to appeal if you're not a licensee, but we're demanding that you be a licensee. You don't get due process unless you do this, but you don't have to do this. And if you don't, then you are denied due process, and we're still going to come after you and penalize you. It seems circular and certainly not applicable here. I think there's jurisdiction. I think the language is clear. We're talking about conditions being imposed, trying to get somebody to be licensed. And frankly, that's what we're trying to do here. My client is trying to get licensed, wasn't aware that they had to do it. They had registered others, did not believe this one was part of it, didn't even own the property at the time they registered others. And so they're more than happy to take care of it and are actively working on it now. In some respects, that issue might even be moot. They did apply, they did get an inspection. There are things that need to be done. However, there was no finding, and I don't believe that the inspection report supports that either, that this is an uninhabitable property. There's definitely work that needs to be done. And I don't think that the inspection report shows otherwise, but we are trying to get that done. And based on that, that's also the reason why we're objecting to the and appealing the notice for relocation. We don't think that these parties need to be relocated. Once the work is done, and it's going to be done promptly, as soon as the permits, of course, are issued, then there should be no issue at all with any habitability concerns for these units. It's just a matter of getting them done. The problem that we've experienced, and the reason for the appeals in the first place, is that these initial notices, the February 11th and the March 2nd notices were never received. We've never seen them before until this March 23rd notice. If we had, we certainly wouldn't have let it go to this, get to this point. And I would point out that it appears that the February 11th letter had no zip code on it. We don't think it was delivered. It doesn't appear to be delivered. There was apparently a certified mailing that perhaps did have a zip code on it, but the return receipt was never signed. I think if something were followed up, regular mail as well, and I don't know that it was, but if it were, then we would have got it one way or the other. We never signed for it. We never saw the delivery. And then with respect to the March 2nd mailing, it looks like it was sent to a P.O. box and never picked up. We know that the registered agent, Dave Simpson, looks like he did get one on the 22nd, the March 22nd notice, again, which is what prompted us to bring this appeal, but we're not aware that he received any others. Some of the ones that did come to the house directly were the March 23rd letter. So that's one of the problems we've had. If we had those notices earlier, we would have certainly acted. We wouldn't have waited until now. What we're really looking for is in filing this appeal is just simply seeking the time and coming together with the city to work and get this resolved, to get it registered, to get the property taken care of, to make sure everything is fine for these tenants. There's certainly no manipulation going on of the one tenant. He does have, as I understand, he does have Asperger's. He was homeless for a while. An organization he was working with helped place him in this property. He likes it there. He's very afraid of being homeless again. I believe his father, as I understand, lives out in Texas, so he's got no one here. There's all we're trying to do is help him put his mind at ease and give him a place to stay. He's happy where he's at. We are aware of the conditions and are working to get him done, and he's happy to cooperate with that, so he doesn't have to leave. But of course, that raises another issue here too. The city's not subject to the eviction moratorium. They've given him relocation assistance, and he's refused. But if this order stands and we have to get him out, how are we supposed to do that? We can't evict him. And if he won't go, won't take the money, won't do anything, that puts us in quite a difficult position as well. Ultimately, we'd rather just get all this done, get the permits issued, get it fixed. Based on the timelines in RCW 5918 for the Residential Landlord Tenant Act, all of these things that need to be done, none of them are life-threatening or considered subject to the day or two timeline. They're all subject to the 10-day or more timeline to start addressing. And we have started doing that, but of course, we're promptly stopped for not having a permit. So we are working on getting that now, but that's really why we're here. I think that you do have jurisdiction to hear these. I think that the notice, especially with respect to March 23rd, is timely. I think the other two we've never received, and I think that raises some of the due process issues that I mentioned. But really, we're just looking to get this fixed and made right for the tenants. That's all we want to do.
Okay. Now, are you going to have a witness here to testify about the fact they didn't receive notice?
Yeah, Mr. Dave Clark is available, and he is online, and he certainly can testify about not receiving.
All right. Well, I think, and of course, I'll let the city respond, but after that point, I think I'll take the jurisdictional issue under advisement, and the parties can present their evidence about whether notice was provided or not as part of their case in chief, and I'll just fold it all together in my final decision there for purposes of efficiency. So, Ms. McCain, did you want to respond to Mr. Harper's jurisdictional arguments?
We give notice as pursuant to the code to the property owner of record. That's done through assessor treasurer data. Those are that's the requirement on terms of notice. The notice was given appropriately. I believe it was limited in the February letter. It was corrected in the March letter. The March second letter, and then the property itself was posted. So the notice is clear. The notice is the same notice they were given on the 23rd, the March 23rd notice. They have ignored us. As far as, trying to get this property up to standard, I take a little issue with that, because I believe I was trying to give Mr. Harper and his client time to get the property. We all want this property taken care of. They promptly went out there and fixed things without permits. Permits are easy to get. They're online. They're easy to get. They have a history of not getting permits to do work on the property. So again, Mr. Gum can explain in more detail on all of this, but the bottom line is we have a property owner who doesn't want to follow the rules and is putting people in jeopardy. There is one other, I believe I already corrected this for Mr. Harper. The only one who deems a property unsafe or uninhabitable is the building official, the city's building official under the IBC and the International Property Maintenance Code, or the building official's designee. And that's what's happened here. So you have an inspection that has a number of items. The number of items is explained to the building official or the building official designee, and they have made the determination that this property is unsafe and needs to be taken care of. So.
Okay. All right. Well, as I said, yeah, I'll take the jurisdictional issue under advisement. And of course, I'm sure the attorneys are aware that you weren't providing testimony today. So if any of your issues regarding proper notice, that kind of thing needs evidence, be sure to get that into your case in chief. As I mentioned, the city goes first unless the parties want to agree otherwise. Ms. McCain, how much time do you think you'll need today to present your side of the case?
20, 30 minutes. Okay. Mr. Gum is here, I believe. So
okay. Sounds good. Mr. Harper, how about yourself?
Oh, probably. Well, as the primary issue for us is really this lack of notice. Probably 10, 20 minutes.
Okay. So we're not in an all day.
I don't think the thing is, I don't think it's really long here. I mean, that's really the primary issue for us. Is we didn't have our position is that we didn't have the notice. So,
okay. All right. Well, look at it.
It has to be
short on either side. So that sounds good. All witness testimony will be taken under oath. All witnesses are subject to cross-examination. Let's deal with the exhibits real quick. I think Exhibit 1 will make the notice of appearance. Exhibit 2 will be Mr. Gum's declaration in support of the city's pre-hearing brief. And Ms. McCain, I take it that Mr. Gum is going to be one of the witnesses testifying today. Is that correct?
That's correct.
So his declaration will be subject to cross-examination once he takes the stand. Do the parties have objections over Exhibits 1 or 2 coming to the record? All right, hearing none, those two are admitted. And well, I guess I'll say Exhibit 3 is the city's pre-hearing brief. Any objections over that? All right, hearing none, that's coming in the record as well. Okay, Mr. McCain, go ahead.
Do you want to put in the notice of appeal too?
Well, that's Exhibit 1.
What's that? Is that Exhibit 1? Oh, I thought that you said notice of appearance. So
I'm sorry. I meant to say appeal. Yeah,
that's what okay.
Thank you for clarifying.
Okay. All right. Thank you.
Notice of appeal. Okay.
All right.
Go ahead.
All right, Mr. Gum, can you put your screen on there? There you are.
All right, Mr. Gum, you need to unmute yourself and let me swear you in. Do you swear affirm to tell the truth, nothing but the truth in this proceeding?
You.
Okay. All right. Go ahead.
Okay, Mr. Gum, can you state your name and occupation for the record, please?
Jeff Gum. I am the program manager for the city of Lakewood and have been for 19 years.
And
for 19 years.
For 19 years. Okay. And your experience is already detailed in your declaration. Let's start with the chronology of the events here in this property. Can you start with October 2018? And maybe first give me a description of the property, would you?
All right, so the property is it's one parcel. It's actually labeled in the assessor's website 7110-146. It contains, I don't know the exact number, 40 some mobile homes on the property. There's also a stick framed property that's addressed 7116 with 2 units. That's on the front of the parcel. So there's stick framed and mobile homes.
Okay.
So starting in October, I was out at this property on October 19th, 2018, and posted a stop work specifically for an upstairs remodel of the property. The stairway was being replaced to the 2nd story. There was plumbing, framing, drywall. When I showed up at the property, the stairs were completely torn out, partially replaced, incorrectly, may I say. The bathtub was ripped out. It was actually cut in half and placed outside of the property. There was a bunch of cabinetry, a bunch of sheetrock. The contractors were inside when I knocked on the door, and you could see through the windows what was going on. So the kitchen was completely gutted. The bathroom was completely gutted. There was doors and so forth being replaced, the stairwell and so forth. So I knocked on the door. The contractor came out. I asked him why all the building materials. I mean, that's the typical question. Hey, what's going on the property? And he said, "Oh, we're not doing anything," and proceeded to kind of get a little bit aggressive. And I just asked him, "Hey, if there's some work going on, you realize it requires permits." Again, he told me that there was nothing going on, slammed the door in my face. So I posted the property with a stop work order because all of the plumbing requirements and stairway and so forth would require a building permit, especially for a second story stairwell, which needs to meet egress requirements for people to safely get out of a property.
Okay. And that's the next question. You know, in terms of permits, and this is going to be a theme throughout this particular property, why do we and the city require people to get permits? Is it just revenue generating because we want to make money, or are there inspections that go along with those permits?
Yeah, and there's inspections that go along with it. It's one of the things that when I go out and post properties with stop work orders, it's not people take them personally. A stop work isn't a stop work for you specifically. It's a stop work that applies to the building. So the building is being stop worked, and the building would require permits to ensure that, yeah, there's inspections that go along with it. You make sure the plumbing is installed correctly. You make sure that the framing is installed correctly. You make sure the doors are installed correctly. You make sure the stairs are installed correctly. I mean, there's not only conditions that require structural and elements that you're changing. Sheetrock is a structural element. Framing is a structural element. Stairways obviously have structural elements that need to meet codes. So it's inspected to make sure that you meet those codes and you meet those requirements so people can safely live inside of a building. That's what a permit is for, and that's what the inspections are for. Okay, and then did you or anyone in the city have an occasion to inspect the property again the following year in 2019? Yeah, in 2019, building inspector Roy Simmons was out on the property. He posted a stop work as well. They were doing interior work on the lower floor. So there's an upper floor and a lower floor. The lower floor was having the interior remodeling. There was sheetrock framing and plumbing and so forth being done. So it was posted with a stop work as well on April 10th, 2019. And in either of those years, 2018 or 19, do you have any record of any permits for this property? No, and in looking, we have no records of any permits for any work on that specific building at all. All right. And that's the duplex, the stick frame duplex? Correct. 7116 146th. To date, there's still no permits to date. To date. Okay. So in January, did you also visit the property, January of this year? Yes. And what did you see on the property or on the duplex this time? So I was out there a number of times this year, but in January, what I saw was a tarp on the roof. It's a property that's kind of been dilapidating. I mean, I've been visiting this property since 2017 when the previous owner had it. So it's got failing siding. It has failing roofing. It's never really been addressed. In January, there was a tarp on the roof. There was all kinds of garbage and so forth strewn about the property. And it's just a property that's been a nuisance and not very well maintained for a number of years.
Okay. Did you make contact with one of the tenants at that time?
In January?
No, in April, excuse me. This year.
In April, I did. I was out there. Well, I made contact with the tenants a number of occasions. So I've talked to them on the phone since the start of the year, as well as going out there. But the last time I was out there would be April 7th. That was when I posted it with another stop work, but we can discuss that later. But April 2nd, specifically, when I was out there, I did talk to the tenants. I went out to return the relocation paperwork. When we get an application for relocation assistance, you have to collect their information. You have to fill out a W-9. You have to get copies of the driver's licenses and so forth. So the individual upstairs, forget his name, Mr. Anderson. Well, I know his last name. He provided me with, he actually gave me his he gave Sam his driver's license, and Sam Maloney is our inspector who picked up the paperwork. Sam Maloney gave it to me. So I took it back to give to Mr. Anderson. And when I went out there, the property manager and his wife were there. They were rather combative. I was walking to the first floor to meet Mr. Pollard because I wanted to hand him some information as well. And I was going to go up to Mr. Anderson's after that and give him his paperwork. So when I arrived on site, the manager of the apartment complex and the trailer park was there. And he asked who I was. I told him what I was doing. And I told him at this point in time, I'm here to bring some paperwork back to Mr. Pollard and let these people know, the renters. At this point in time, I don't think I can hand them relocation assistance because there was a contestation of the relocation or of some sort of those lines. So they proceeded to tell me that the city was wrong and Mr. Pollard was standing there. The city was wrong. The tenants don't have to move and the building's not unsafe and nobody can say it's unsafe and nobody can be evicted at this point in time. So I had to explain to the tenant with Mr. Pollard standing there. I said, this isn't an eviction process. This is a dangerous building process. The city has determined that this building is dangerous. It's got issues that are life threatening to you people living in there. And that's our position. And so the managers kept telling us that he didn't have to leave. And I walked away. As I went upstairs, the manager's wife went upstairs to talk to Mr. Anderson, and she told him again, same thing. You don't have to leave. This building's not, I'm standing there on the stairwell. She's telling him this. No, you don't have to leave and blah, blah, blah. And this city doesn't have the right to do this. So I handed him his paperwork. I said, hey, same thing to you. This is what the city's determined. This is where we're at. This is what we're up to. This is why I'm here. Here's your paperwork. Have a nice day. And then I left.
Okay. And at that time, was there a rental housing license for the property?
They did. They applied for their rental license, I believe, on the somewhere around the 30th. I'd have to look at the specifics.
No, I meant at the time that you were talking to the tenants. Was there a license pending and at any time prior to March 30th?
No, there was not a license before that. No.
Okay. And are you permitted to have renters without a license property under the rental housing safety program? No,
that is a requirement. You cannot without a license.
You may not, as a property owner, rent to anyone without a rental housing license. Is that correct?
That is correct.
Okay. So going forward, on March 11th of this year, you sent a letter to the property owner to notify them that they were not in compliance with the rental housing safety program. Is that right?
That is correct.
Okay. And who did you send it to?
That letter went out to, when we send these notices out, I find it interesting that, I don't know, that somebody claims they don't get a notice. So we send them to whomever owns the property that's listed on the assessor's website. So when I send out that notice, the first thing I do is I go to the assessor's website, you pull up the parcel. The assessor's website lists the owner, it lists the address, it lists everything. And that's where that goes to. So that is where that letter was sent to. And when it went out, the letter did have a zip code on the letter. So it went out as mailed.
Okay, all right. And then in March 2nd, you sent out another letter to the property owner, effectively repeating that they were not in compliance. Is that right?
Yeah. It's not the same letter. It's a much stronger letter at that point. But yes.
Okay. So, and who did you send it to at that time, in March 2nd?
So what happens is when we send a letter out to a PO box, and this is where I find it interesting, is someone would say there's our circular reference, but when there's a PO box, not very often are those letters picked up. So what happens is when you send it to where you're supposed to and it's not picked up, I'm not certain if that's a deliberate intent or I don't know, some way to say, hey, you know what, we never got a letter because it was sent to a PO box, but we never picked up the letter at the PO box, so we never got any notification. So when we get the letter back, now I am in a position where saying, all right, I need to figure out who can actually get this letter. So when we get a letter back, now it's my understanding, guess what? Now I need to actually find out a way to get this thing to these people because clearly the PO box isn't working. So now I did a LLC search of everybody that owned this property. So I found Dave Clark. I found.
Slow down. So an LLC that because it's owned by Cedrona Park LLC, a limited liability corporation. So
Yes.
You do a corporation search.
Yes.
The Washington Secretary of State website, correct?
Yep. So when you do an LLC search, then you find registered parties, you find the owners, you find all kinds of information in addition to other LLCs that have an interest in the property, which is what I did on the second notice. So I sent it to the PO box as listed on the website for the assessor. I sent it to Cedrona Park LLC. I sent it to Dave Clark's representatives and so forth. So I casted a broader net on the second time. So it did go out to all of those people. And then it was when we do these, I always send them first class and certified. So there's 2 letters that always go out. So that's the typical mailing. If they choose not to accept a certified, there's usually a first class that follows it as well.
Okay. And that's what was done in this case?
Yes.
Okay. And those are attached to the certified mail and first class, as well as the LLC search are attached to your declaration. Is that correct?
That is correct.
Okay. So on March 5th, you work with Sam Maloney, correct? He works basically for you. He's the program coordinator.
Yes, he works under me.
Yes. Okay. And did he post the property on March 5th?
He did.
Okay. And so why did you post the property too?
At that point, where that notice on March 11th is a notice that the property is unsafe. So at that point in time, we post the property with the notice of noncompliance and unsafe units. That's standard practice.
Oh, I'm sorry. You said March 11th. I believe it was March 5th that was posted. That's unsafe. Right, Sam. Yeah. Okay.
March 5th.
Okay. So, and again, that gives notice to both the tenants as well as the landlord if the landlord's engaged in this or her property, correct?
Correct.
Okay. All right. So, on March 23rd, what did you send out?
March 23rd would have been a relocation notice to Mr. Pollard. So what we do when we show up on site, you have to gather all the information. You have to get copies of tenant leases and so forth. So it takes a little while. So on March 23rd, when I had all that information, I sent out a notice that says, dear owner, you're responsible for X amount of relocation for this tenant because of these reasons. So that was the notice that was sent out on March 23rd to Mr. Pollard.
Okay. And could you explain why you came to, I believe it was $2,000 per unit. Is that correct?
Yeah, it was 3 months rent plus deposits or $2,000, whichever is greater. And that was in the notice, and it listed the dollar amount specifically.
Okay. All right. And did you hear from the property owner at that point?
I did not.
Okay. And March 31st, you sent out another notice, correct, to the renters?
I did. That was to the person that lived upstairs, Mr. Anderson.
Okay. And you sent notice of that letter to the same people that you sent it to when you passed the wider net in March 2nd, I believe it was?
I did, yes. First class. Every mailing that we do goes out first class certified, and I have proof of all of those.
Okay, all right. And let's see, did you go out? Well, on March 31st, the property owner filed this appeal. When did they file for their application for actual rental housing license? Was that March 30th?
I believe it was March 30th.
Okay, all right. And since that time period, have you had occasion to visit the property again?
Yes, I was out there. We discussed earlier, I was out there April 2nd, returning paperwork to the tenants. And then I was out there on April 7th as well.
Okay, so, and I think on the April 2nd one, I'm sorry. When did you see illegal construction? That was the one I'm trying to find here.
Oh, that's April 7th.
April 7th, excuse me. Yeah.
Yeah. So when we received the April 3rd, I think it was April 3rd inspection letter from the contractor, from the inspector, sorry, we sent out an email. What typically we do is we get reports from private inspectors. They're logged into our electronic system. We send those electronically via email to the owner that says, hey, here's the report. In this case, they already knew the report, but we still have to enter it. So we send them an email on April 6th saying, here's all the issues with your property that the property owner found. Here's what's required of permits and so forth. So on April 6th, I was talking to Mr. Pollard to make sure that he was aware of timelines. He was looking for a place to move out of there. He had some issues with one of his, I believe his daughter that he's working on getting custody for and needed to find a better place to live. So he was getting out of there. Was talking to him and he said, oh yeah, they're doing a bunch of work on the siding and roofing. And I said, what? And he said, yeah, there's all kinds of work going on in this property. So after talking with him, the next day I drove out to Cedrona Park on April 7th. They had a large section of roofing being replaced. They tore off the back section of wall, the siding. It's on the, what would that be, southwest elevation. The siding was completely torn off of the building. It was exposed. You can see all the insulation and so forth that was there. The roof, they were I won't say patching it quite properly. They were kind of piecemealing the roof together, trying to make it so it wouldn't leak anymore. They pulled the tarp back and we're fixing sections of it. And the entire roof is failing. It's not something that you can simply patch here and patch there. It's had leaking issues over the years. And what happens is once a roof gets to that point and it's leaked inside of a building, you don't get to patch it anymore. You have to strip the roof off. You have to have the sheathing repaired because typically when you have water that goes through a roof, it hits sheathing below the roof. It only lasts so long when water's hitting it. So, and then the siding as well. You need a permit to do siding. I mean, the whole point is to do it properly to protect the tenants from water intrusion into the unit. So those are permittable items and those are inspectable items. And there was no permit on hand, so I did post it with a stop work.
So going back to the private inspector's report, can you detail what was in that report from the private inspector?
Yeah, I look at my computer so I can remember all of the things. So the private inspector was Todd Oberfeld. Todd's worked for the city of Lakewood for 3 or 4 years now, and he's a reasonably thorough inspector. He usually doesn't miss a lot. I find a few things that he misses, but I don't know. I look at things through a building inspector's eyes versus a private inspector. So I tend to find a few more things. But so when I went through his report, it confirmed kind of the things that I have issues with the property for life safety. There was in the report, it noted that the siding was badly deteriorated and due for replacement. So we've got issues with the siding not protecting the tenants from the elements and the weather. It noted that the roof is damaged and due for replacement. So again, you've got an extremely deteriorated roof that I had already noted, not protecting the tenants from the weather and exterior or the elements from the exterior. It noted the gutters were due for replacement, and yeah, there's sections where the gutters are failing, falling off, and needing replacement. And gutters don't sound like a big deal, but when gutters fail, you end up with water that runs down the side of a building, deteriorating the siding even further. It tends to wash out foundations over time if you don't protect that. It sounds inane, but it really isn't over time. So it's something that needs to be done. They had windows in his report that do not open properly. From a building inspector's perspective, if you have a window that does not open properly and you have a fire in a building, you have one way to get out. It's through the window. That's an extremely important safety egress component. If you don't have windows that operate properly, people cannot get out of a building. That's a huge red flag for me. You've got in his report, there's broken windows, bedroom doors, which are missing or broken. Again, you've got egress requirements. If bedroom doors are broken and aren't working properly, and you've got windows that don't open, and so there's a fire in the building, it's unexcusable. You can't have that for a tenant living in a building. If they can't get out of there safely, I mean, you're jeopardizing their lives. That's not something that I, as a building inspector, would allow. Damage to the interior walls. The damage to the interior walls would be kind of what I've seen over the time, and that's why we posted with the stop work, the sheetrock and framing and so forth. So over the stop works, we posted it because they were doing sheetrock work and framing and interior work without permits. And the inspector on his inspection, the private inspection, noticed that there was damage to the interior walls. So again, things that require permits to make sure that it's done properly, the framing and the structure isn't damaged or compromised. He noted there was no smoke detectors or carbon monoxide detectors present throughout the structure. That's a simple building code. Again, you don't have any way, if you have a fire, there's not only is there no way to get out, there's no notification that there is a fire. Smoke detectors are there for a reason. When there's a fire, they alert you to get out of the building. There was a notice or he wrote on his inspection there was damaged and filthy wall heaters, which were improperly maintained. Again, sounds like kind of not a big issue, but what a wall heater is it's typically a fan forced heater. If those aren't cleaned out over time, they build up with all kinds of dust and lint and debris, and there's a heating element in there. And as that dust and debris builds up over time and gets closer to the heating element, you end up with something that could potentially catch on fire. So those do have a maintenance requirement when you install them. It's in the instructions manual. You're supposed to take the covers off. You're supposed to clean those things out. You're supposed to vacuum them, because the manufacturer knows if they're not cleaned out and you get a bunch of dust building up in that thing, it's ultimately a fire issue, a hazard. So they also noted, going through my list, damage to the wall surround and allowing water intrusion, and a shower wall surround. So again, you've got a plumbing fixture that's allowing water to get into the walls, which could cause structural damage. Some things that we don't like to see when you have a shower leaking, what happens is it usually rots the floor underneath and around the shower and causes hazardous elements for somebody walking into a building or potentially falling through. The notice also said kitchen outlets were lacking proper GFCI protection. GFCI protection is a ground fault circuit interrupter. So if somebody were using the kitchen sink, they're required within 6 feet of a water source. So if you're using some sort of an electrical appliance within a kitchen sink and you make contact with a water source, and the electrical circuit is basically you and that outlet now, all the electricity goes through you into the sink and you end up getting electrocuted. So GFCI basically just trips that circuit, shuts off the power, so there is no longer any electricity going in there. So that's a building code requirement. It's a life safety issue if they're not there. The notice, or the inspector also noticed dead cockroaches found in the structure. Where you find dead cockroaches, you find live cockroaches. So that's again, a health and safety issue. The crawl space was noted not being properly protected from pests and rodents. Again, I mean, if you've got rodents getting into your building, you've got cockroaches getting into your building, you've got rats and so forth getting underneath your building. That's a health and safety issue. And then it noted rubbish stored about the property. So again, there's a lot of life and health safety issues that the inspector noticed. And one or two of those may not be such a big deal, but when you have that number of life and safety and structural and protecting you from the elements issues, that's when the building department comes in and says, all right, you can't have somebody living in something with this many issues going on. It's just not safe.
So in terms of designation, as the city's program manager, you're designated by the building official, is that correct? And by the city code to make determinations of unsafe or unfit buildings, is that right?
I am. Yes.
Okay. And the private inspectors, are they given that designation?
They are not.
I don't have any other questions at this time.
Okay, Mr. Harper, did you have any cross you wanted to do? And you'll have to unmute yourself.
Yes, thank you. Sorry about that. Mr. Gum, you can only make the determination based on the information you've been given. Is that correct?
I can only make what determination?
The one you just said about safety.
I can make a determination that a building is unsafe. Is that what you're asking?
Right.
I can make a determination if a building is unsafe based upon my observations and any information that's provided to me thereafter.
Okay. And if the information's not complete, do you still make those determinations, or do you try to get more information?
It's you kind of have to go by property. So if you have a building that rises to that level, you don't necessarily need any additional information other than to what you're visually confirming.
Okay. So you're aware that with the information you're given on this house, that the crawl space and the attic weren't entered into and excluded from the inspection?
I am aware that wouldn't make a building safe or unsafe whether somebody goes into it. That's typical for a private inspector not to inspect. As a building inspector as well, we don't crawl through an attic or a crawl space to determine a building is unsafe or not. You look at the conditions present on the building that are visible.
And then if the inspector says that a determination is made that animals could be getting into the crawl space, but if nobody checks the crawl space, there's no way to know that, is there?
There is no way. However, the building code does require that all access points to an attic in this case, a crawl space are properly protected from rodents, and they were not. That's what he was noticing.
And that's the assumption made, despite the fact that nobody actually inspected those areas, right?
You're not making the assumption of the crawl space. You're making the assumption that the accesses are not properly protected. And when I did go around the building on April 7th, it was clear that the crawl spaces were not protected. There's vents, there's crawl space accesses, there's multiple accesses to a crawl space, and they all have to be properly protected.
I have no other questions.
Okay, Ms. McCain, did you have any redirect?
No, thank you, Your Honor.
Did the city have any other witnesses?
No, Your Honor.
Okay. Well, this is a good point. I should have raised this earlier. This works now as well because the appellant will have an opportunity for rebuttal. That is a disclosure of ex parte contacts. I think that this is the case that applies where I was accidentally CC'd an email from Mr. Gum, I think asking you about some legal advice regarding rental housing. And I think it was this case. I actually, the first couple sentences, I saw that it wasn't intended to go to me. I stopped reading it, but I think Ms. McCain, you in a subsequent email said you were going to submit a copy of it to the appellant. And I mean, has that been done? And
yes.
Okay. All right.
And I discussed it with Mr. Harper. I asked him if he wanted to exercise it. I mean, we can try for a pro tem hearing examiner. I didn't think you had gotten it either. I think what happened was the city clerk in arranging, she asked first about appeal fees. And then at one point or another, Jeff and I thought it was only to the city clerk, not
Right.
including you. So that's when I sent my message to you, please disregard, and then send it off to Mr. Harper saying, yeah, here's what happened.
Well, and as I said, I didn't read it. I don't remember much about it, except like I said, it was about the rental housing issues and that kind of thing. I mean, Mr. Harper, do you want that email made a part of the record, or need a chance to respond to it? How do you want to deal with that?
We can. I saw it. I wasn't overly concerned about it.
Okay, all right. Well, I guess to be safe, let's put that in the record. I think Ms. McCain, recall what the date was of that email, or?
Yeah, would have to look it up. I can do that while we maybe
okay.
continue.
Yeah, I mean, I think we all understand what email it is anyway, so I'll say that's
okay.
it.
I can forward it to you separately so that it'll be top of your box. How's that?
Okay. All right, yeah, so we'll make that an exhibit 4. I'll put that in the record. Okay, Mr. Harper, let's move on to you at this point then. And just to be clear, if you want to respond to that email, provide rebuttal evidence, you have that right now to do that as well.
Well, as I understand the email, it was essentially the position that was taken by the city at the beginning here regarding jurisdiction. So I don't know that, I don't know how important it is. I trust that you took the right steps and stopped reading it. I trust that Ms. McCain got her email to you about it soon enough as well. I don't know that it really changes or affects anything here. So again, I had a chance to see it as well, and I'm not really concerned about it.
Okay.
As I mentioned at the beginning, our primary focus was really on the notice issue. I don't think we dispute that work needs to be done. We dispute that it's uninhabitable or dangerous, but we don't dispute that work needs to be done. And as I said before at the outset, we're willing to take care of it and are actively trying to get that taken care of. So to that end, that's really all we're looking at is the notice issue.
Okay. So it sounds like, I mean, in terms of the substantive outcome, the only thing you're trying to, the only remedy you're seeking is that you don't have to pay the relocation assistance, essentially. I mean, is that basically your argument? You didn't get notice that you could be subject to this relocation, therefore you shouldn't have to pay it?
That's correct. We just want the opportunity to get it resolved, repaired, and get the registration done.
Okay. Okay.
And now that he's fleshed out this part of his argument again, I would say that the hearing examiner's powers are limited to what the city council has granted. And the city council has not granted the hearing examiner authority to debate or discuss relocation assistance. If the property owner wants to debate or discuss relocation assistance, they have an opportunity to bring an action in Superior Court. That's the opportunity. That's the remedy. It's not to bring this in front of the hearing examiner. So.
Okay. Well, yeah, that's part of what I'll take it under advisement there.
Okay. Yes, thank you.
Yeah.
And I did send that email. I sent the one where I said, please don't read.
Okay. Great. All right. Mr. Harper, did you have a witness you wanted to present then?
Yeah, I would just call Dave Clark.
Okay. Mr. Clark, let me swear you in. Do you swear affirm to tell the truth and nothing but the truth in this proceeding? Okay. Oh, you have to unmute yourself, Mr. Clark. You're still on mute.
How's that?
Yeah,
I do.
We can hear you. Great. Okay. All right. Go ahead, Mr. Harper.
Thank you. Mr. Clark, can you identify yourself for the record? Your full name, please.
David Wilford Clark.
And how are you related to Cedrona Park?
I am general manager of the LLC, and I am also a member of the LLC through DCI Investments, which is an investment company.
Okay. And are you familiar with the property at issue with this hearing today?
Oh, yes.
And how are you familiar with it?
We own it.
Okay,
We
you
own it. We've owned the property across the street for 20 years before we owned it. So, yeah, we're familiar with the property.
Okay, and do you recall when you purchased it?
We purchased it on November 30th of 2017.
And are you familiar with the City of Lakewood's rental housing registration program?
Yes, I am.
Okay. And did you register this property at that time?
No, I didn't.
And why not?
The best I can remember, I went downtown and registered all of the rental properties that we owned in sometime around mid 2017. And we've got a property in Tillicum. We have a duplex up the street. We had a rental trailer down on Woodbrook Drive that isn't there anymore. And I'm thinking that this happened in that window before we bought this property. I know it would have happened after April of 2017 because that's when we sold Woodbrook Mobile Home Park, and that had a bunch of rental houses in it that would have needed to be registered. So I'm thinking that when I registered our properties, it was after April and probably before October, which is when we knew we were buying this one. And it just didn't get done.
And have you registered since?
No. Well, Robert Dowd registered it on the 30th or whatever. Well, 30th of March is as part of this once we caught up with the fact that it wasn't registered and there was enforcement action pending and it was required and we missed it.
Okay. And when did you first learn about the registration and inspection issues in this case?
My wife signed for the March 23 letter on March 25th, and Dave Simpson had emailed me the letter he had signed for the front page of it on March 22nd.
Had you seen any previous notices prior to that one?
No.
Okay. Are the addresses in this case accurate for sending notices to Cedrona Park? And I'll start with the address, the P.O. Box 4438 in Tumwater.
That is my P.O. box in Tumwater.
And that would be an accurate address for sending notice to Cedrona?
As long as there's a zip code attached to it.
Okay.
Which
if there's no zip code?
Then it would be an inaccurate address.
Okay.
The zip code is 98501-0438.
Okay. And have you seen a copy of some of the other notices in this case?
Yes, all the prior notices were included with the March 23 letter, which was the one to Kurt Pollard about the 7-day notice to relocate and move out.
And did those previous notices have zip codes?
The February 11th letter did not have a zip code. The March 2nd letter did have, I think it had several addresses on it. I'd have to look it up here to see. But that one was addressed to several places.
And did you ever get that in your P.O. box?
No, I had gotten notice there was a certified letter and I didn't pick it up.
Did you ever get any regular mail?
No.
At the P.O. box?
No, I did not.
Okay. How about at your home?
Regular mail, no.
Did either Mr. Pollard or Mr. Anderson ever notify you about receiving notices posted on their doors?
No.
Do you know if they ever notified Mr. Dowd?
I don't.
or Mr. Simpson?
No,
And just to clarify, Mr. Dowd and Mr. Simpson, are they also members of Cedrona Park LLC?
yes.
Do you recall the stop work orders in 2018?
Oh, yes.
What happened there?
Robert Dowd's son was doing some work in there. A stop work order was posted, and he went down to the city to clear it, find out what we needed to do, and they didn't have a record of it. There was some confusion, so just didn't worry about it after that.
Okay, how about in 2019?
I believe it was the same circumstance.
Did either of those issues ever get resolved?
No.
How about now? Do you have a permit now for the work that's needing to be done on the property?
I have some drawings on my desk. I'm working on the permits.
Okay. And what are those drawings for?
For roofing and siding and steps, and the interior. I have to do different drawings of the rooms, and then go through the letter and find out. I need to go back out and find out which windows we need to replace and stuff like that. So it's a work in process, and it takes me a little longer because I don't do it all that often.
Okay. And you're actively working on this now?
Yes.
Okay. All right. I have no other questions.
Okay, Ms. McCain, any cross?
Yes, and it's going to be awkward because we have this Zoom. Mr. Clark, I would ask Mr. Harper, may I have Mr. Clark's email address? I've sent both Mr. Harper and Mr. Ulbrich a copy. I know you already have it, of Mr. Gumb's declaration. It has a number of exhibits, and I want to talk to Mr. Clark about those exhibits.
I have it. I have access. I have access to it on my screen here.
Okay. All right. Great. So I would bring your attention, Mr. Clark, to the first exhibit. That's Exhibit C. This is the February 11th Notice of Rental Housing Safety Program, non-compliant property.
Do you have a page number? Do you have a page number?
Yeah, hang on. I'll scroll down.
Okay, I'm on A. Yeah. No.
Okay, so it's 23.
Okay. I've
And
got
maybe
I've got it. Okay.
You got it.
Yeah.
Okay. So, and that it's actually 25 where it says February 11th, 2020.
Yeah.
And as you said, there is no zip code after Tumwater, Washington. But if you look down at the certified mailing that's attached to it, or actually, I guess it's up for whatever reason it became before. So if you look on page 24, the certified copy there, that has a zip code, doesn't it?
Yes, it does.
Okay, so it actually does have a zip code, at least
Well,
as
actually,
US. Yeah.
That's the receipt that somebody fills out after they mail it. That's not
No, that's actually done through at the time that you actually file or you send a mail piece through the certified mail. You fill that out at that time. At the time that you fill it out, that's what the USPS uses in order to deliver mail. So while the letter itself might not have had a zip code, what USPS uses to deliver mail had a zip code. So scrolling down a little bit farther here to Exhibit D, I believe this is the March 2nd notice of noncompliance, and the tracking numbers and how I guess they start all of this. I'm sorry. But again, we've got a number of people. This was the one where Mr. Gum threw the net a little wider. And your address is, if I can read this to you, P.O. Box 4438, and the physical address is 4907 Laura Street, Southeast. Is that correct?
That's correct.
In Olympia? Okay. And so if you scroll down, all the certified mailing and the payment that Lakewood paid in order to have all of these certified are attached. Sending it to David Simpson, P.O. Box 1441, Mercer Island, Cedrona Park LLC, David Simpson at the 72nd Street or 2nd Avenue Southeast address in Mercer Island. And then DCI Investment, you, David Clark, at your P.O. Box and your physical address. There's a rule in the law that when something is sent out through USPS, that it's presumed to have arrived at the location identified. Do you know about that legal principle, Mr. Clark?
Not specifically.
Okay.
I mean, I would say it sounds one step less than vaguely familiar.
Okay.
So
you are presumed to have received those notices, the February 11th and the March 2nd, regardless, unless you can show something other.
that's quite a magic trick to show you didn't get something that you didn't get.
Are you on the property? Did you see the unsafe posting on March 5th?
No, I don't go to that property very often.
Okay.
So the only thing I can.
That's a hazard of being an absentee landlord, isn't it?
Yeah.
Objection.
Okay. Have you applied for any permits, Mr. Clark?
Any permits
property.
for this duplex? No, I have not.
And you have applied for a license, a rental housing license, as you said, for other properties, including a duplex. So you know that the rental housing safety program applies to this duplex, correct?
I do now.
Okay.
It fell through the cracks.
Okay. I don't have anything further, Your Honor. Thank you.
Okay. Mr. Harper, any redirect?
Yeah, Mr. Clark, have you sent a certified mailing before?
Yes, I do certified mailings for tax returns, and occasionally, yeah, I do send certified mailings.
And you're familiar with the certified mail receipts that you were just looking at previously?
Yes.
Do you know who writes in the information for send to at the bottom of those receipts?
Whoever types it up or makes it. I mean,
Post office doesn't do it.
no, they typically just, there's a number on the left there. I'm looking at page 33. There's a tracking number on the left, and I believe that's attached to something, and they rip it off and hand it back to you when they tape the other side onto your envelope. But the idea that it has a zip code on your receipt, I do not believe proves that a zip code was actually put on the letter that was physically sent out.
Okay, thank you. And no further questions.
Okay. All right. Let's see, Ms. McCain, any rebuttal? Or I'm sorry, Mr. Harper, did you have any other witnesses?
No other witnesses.
Okay. All right, Ms. McCain, do you have any rebuttal you wanted to present?
That's
Okay.
nothing further, Your Honor.
Did the parties want to
thank
make any concluding comments, or Mr. Harper?
Just what we've been saying. Mr. Clark testified he did not get these until the March 23rd one, when that one came. For whatever reason, the certified mailing receipts are fine. They show that perhaps Mr. Gum took these to the post office. got the certified mailing, sent them out, but the certified mail receipts do not show that the envelopes were correct. The letter appears to show that they were missing zip codes. If there's a missing zip code, it doesn't necessarily mean that it got mailed out. So you can deem that it's been mailed, but that doesn't mean that it was done correctly. I think that, I think as anybody knows, if you use Microsoft Word, for example, and you're writing a letter and then you print out the envelope for it, and perhaps that's what happened here, or maybe not, I don't know. But if you presume that's what happened, and you didn't have the zip code on the letter, well, that's not going to transfer over to the envelope function either. And you can write on the certified mail that you had the address and zip code correct, but you may not have had it done actually on the letter. The fact is that, as Mr. Clark testified, he did not receive them. He didn't get those notices. He didn't get any of them until this 23rd notice that was sent to him, and that his wife, I believe, actually signed for. That was the first time we saw these. It's the first time that we knew there was an issue. And promptly, once we did, they took action to remedy the problem, to go and apply, get the application in, to go and get an inspection done, to do what the city wanted, and then to engage in making the repairs that were necessary to bring the property up to code. I think that, that's, again, the primary issue here is that notice was not received. And I think that if regardless of what the mailbox rule might say, if there's a defect in what you're sending out in the first place, it doesn't matter. It's not ever going to get there. And that would be an exception to the mailbox rule. The other thing, I think, is if we look closer at the actual inspection report, the inspection report is telling. There are certain assumptions I think were clearly made here about the condition of the property. I think that the photographs also included with Mr. Gumb's declaration are date stamps. You can see what the property looked like in 2017, 18, and 19. And yeah, I can understand the city's position that this is a rough property. But in the 2021 photos show that it certainly has made some improvements. Yeah, it needs a new roof. We don't deny that. Sure, it needs some siding and some work on the windows, needs a few other odds and ends, but there's no evidence that there's any issues with the attic. There's no evidence that there's any issues with the crawl space. Those things weren't inspected. The assumptions made about those things are that assumptions based on perhaps, and what it looks like to me, on prior experiences with these owners. Perhaps that's tainting Mr. Gumb's whole outlook on this property, that he's got a bone to pick with him from earlier negative experiences. Now he's taking it out on him now with this as well, reading more into this inspection report than is there. Fact is that Cedrona Park is trying to get this fixed. They know about it. They're working on it. It's something that looks like it may have just inadvertently fell through the cracks when they purchased it. But they're not trying to be difficult. They're not trying to get away with something. They're trying to do the right thing and make the city happy. And that's what they want to do. They should be allowed to do that. They should be allowed to get this done, get their permits submitted, and make the city happy. They don't want it to be a situation where the city's got a dilapidated, a derelict house. They don't want their tenants to have a poor living situation, especially for Mr. Anderson. They like the kid. They are trying to help him. Of course, we're trying to help Mr. Pollard, but he's already left. They can't do anything about that. But that is really what this all boils down to, is they just want to be able to do the right thing and to be able to get this taken care of. That's all we're trying to do. That's all we're asking for. That's all we're asking be allowed to be done here, is to get this done. And we don't think that relocation assistance should be required. We think that they should, not have any fines, which may or may not come. I mean, if this is something that ends up taking much longer, I could understand the city maybe being upset about that. That'd be another issue for another day. But I think that for now, they need to be able to do what they want to do and need to do to make the city happy, and they should do it. They've got notice now. They did not have it before. Let them do the right thing. That's all they want to do. That's
Okay.
Rob. I'll leave it there.
Okay, great. Thank you, Mr. Harper. Ms. McCain, any comments you want to make?
Even if it's believable that Mr. Clark never got notice, and frankly, it is not believable. The point is the city had to give notice to the owner of record, the LLC. The registered agent is Mr. Simpson in Mercer Island. And even if you could say the February notice was somehow deficient, and it's not, there is a tracking number demonstrating from the USPS that the item was delivered to Mr. Simpson at Mercer Island, March 8th at 10:16 a.m. That's Exhibit D, page 30 of Mr. Gumb's exhibit. So the notice is not an issue. And when I look at how much money the city taxpayers are paying to provide notice of a defective substandard property, it's appalling. In addition, the property is noticed. It's posted. And the property owner isn't looking at that either. And that was done March 8th or March 5th. The only thing that has brought the owner or a representative of this LLC forward to the city is the specter of having to pay $4,000 to rental tenants who have been living in substandard housing for years, owned by a person who does not apply for permits, does unpermitted work, and puts people at risk. That's what we're talking here. This is a completely meritless appeal and should be, the city's decision should be sustained. That's the end of the city's position on this. Thank you.
Thank you, Ms. McCain. And just to make sure I understand the record properly as to the relocation assistance, has it been spent on one of the tenants and the other tenant has refused it? The city believes that tenant may have some cognitive issues, and that could be why they, at least in part, refused it. I mean, if I find that find that I can address the issue and find that the appellant owes that money, does the city plan on trying once again to make that tenant take the money, or what are your plans here?
Yeah, Your Honor, we can't make anyone take anything. We offer assistance, and that's all we can do. What the problem here is, this property owner has spent an awful lot of time appealing notice that he was given, appealing relocation, which he owes, and not spending enough time taking care of his property. That's the problem here.
Yeah. Okay. Got it. All right. Well, I will, I'll get my decision out as quickly as possible. I mean, the 10 business days is the standard. I'll try to get it out earlier, considering the urgency of the situation. Hopefully in about a week or so. I'll shoot for that. Might be a few days after that, but I'll get it out soon. I mean, the two major issues here, obviously, one is the jurisdictional, the other is the notice issue. Beyond that, it doesn't sound like really there's a lot that's being contested here. So it shouldn't take me too long to put all this together. I appreciate all your participation this morning, and we are adjourned for today. Thank you. Have a good afternoon.
Thank you, Your Honor.
Thank you.